Good evening and welcome to the Personal Injury Show. My name's Harry Nowicki. I'm with my colleague Tony Carbone.
Good evening, viewers.
Welcome. You're on deck.
I'm happy to be back, Harry.
You're not relegated to the reserves.
No.
Tony, we've had a lot of interest in questions from viewers and situations which they've thrown up. Some of them we don't have a lot of details on, but they raise sort of interesting issues about people who are injured in work, mainly work accidents, and what they can and can't do. But you know, you can tell us how you assess the claim. One query we've got is a self-employed truck driver. The company he worked for asked him to incorporate, register a company, which he did, and then he is then subsequently injured. What rights does he have? He's working for a transport company, but he's, as I say, characterised maybe as a self-employed truck driver.
I think the problem with him is that he's not insured. Is that correct? He doesn't have his own insurance?
He doesn't have his own work cover insurance.
I mean, in his case, I think that if we can deem him as a worker under the provisions of the Accident and Compensation Act, a deemed worker because he's working for that one company, doesn't work for anyone else exclusively.
So one company provides him with
his contract.
His contract provides him with where to go and what to deliver.
Well, they tell him what to do, when to do it. You know.
But he's incorporated.
Yeah, it doesn't matter.
Makes no difference.
No.
You can tear away.
There's a number of sections under the Act that pick up people in those circumstances, and the common law and also the statute and other cases like that.
So he can get benefits even though he's got no work cover.
He becomes a deemed
himself.
worker, which gives him, he's entitled to statutory benefits, which is loss of income, reasonable medical and like expenses, but it gets better than that because if the person gets injured in negligent circumstances, he can probably sue his employer or a third party if he satisfies the provisions of the Accident and Compensation Act in relation to suing.
Yeah. So even though, as I say, he's incorporated without any workers' comp for that company that's incorporated.
It doesn't matter.
It doesn't
necessarily matter. There's other things you've got to look at.
The legislation in Victoria tries to look after people who are injured in the course of work, no matter how they're sort of structured.
It'd be a different situation if you're a subcontractor. But,
a truly subcontractor.
Yeah, a true subcontractor.
Like a plumber goes from job to job. Each day there's a different person who
The primary company doesn't have any control over
and
what you do.
The prudent thing for the plumber would be to take out insurance.
Yeah, you'd want income protection
and a lump
some
sum.
trauma type cover in case you sustain a really nasty injury, and that way you could get a lump sum that try and look after yourself in the future.
Yeah. So that's different from the truck driver.
The building industry is interesting, Harry.
It's somewhere in between.
Yeah, because what they've done is they've still got benefits under the IncoLink system, which is pretty beneficial.
Yeah, it's like a sort of a superannuation. It's ancillary or related to a superannuation. But the building industry is unusual, and there's lots of interesting cases about the building industry. We probably might do a whole program on the building industry and injuries arising from the building industry. Another person has sent in a query about they've got an accepted work cover claim. They are having treatment. It's hydrotherapy, and it's a back claim. They're having treatment, hydrotherapy, and then they slip in a shower and damage their shoulder in the course of that treatment.
Well, the Act covers you again. You can claim that new injury as part of your claim.
So there's a back injury, now there's a shoulder injury.
Yeah, you'd probably throw in another primary claim, I think, just to make sure that they cover your reasonable medical and like expenses.
But if you're injured whilst having treatment,
you're protected, you're covered.
So you're still covered.
Yeah. The legislation picks you up.
And it picks you up because it's foreseeable that someone who's having treatment, something could go wrong or something.
All right, let me put this scenario to you. Assuming this person that was getting treated for the back doesn't have a serious back injury, but it turns out the shoulder's serious. What do you say? Can you sue for negligence?
You could sue probably the employer if the employer's at fault with the original injury, and say that that's part of a.
Or you might even pick up a serious injury certificate under the Accident and Compensation Act, and then sue the third party, which is
the wrongdoer if
Yeah,
if they're at fault.
you know, you might even sue the pool, the place where they went for the hydrotherapy.
You could. So, and another situation is where somebody who goes in for an operation, they've got a hernia injury at work. They then go in for an operation.
That was my case. Yeah.
It could have been your case, but could have been someone else's case. I'm not sure. And then they go into hospital for a hernia operation. It goes terribly wrong.
Yeah, nerve damage, significant nerve damage.
So the doctor's at fault.
Well, we didn't sue the doctor. What we did was we sued the employer. We proved negligence against the employer, and we got a significant payout for the damage to the hernia and the adjoining areas like the abdomen and other things like that.
He was quite a young man, and he was in constant pain.
Yeah, yeah.
And there was permanent nerve damage.
It may be that the insurer could probably sue the doctor themselves to recover what they paid out. That's another issue altogether.
Yeah, but it's from the point of view of the injured worker, it doesn't concern him.
No, no.
He's happy to get paid.
The injured worker gets his money and tries to get on with his life as best as he can.
Having to get paid.
Yes.
And then with work cover, there's all sorts of disputes about medical expenses.
Well, can I give you the one that I got, Harry?
Yeah.
I got the fellow that's injured his back, and his query is that he's got problems with his spouse, sexual problems. He says he can't get an erection. He's gone to his doctor, got a letter to say that he wants a Viagra's, and he got knocked back. What do you think?
Well, it's a dispute about what's reasonable in medical expenses. He'd have to go to conciliation and argue his case to say that he's got an accepted injury, which is the back, and that leads to all sorts of consequences. He mightn't be able to sleep, so he might have prescription for sleeping pills. He's got marital problems, as you say, and he then says it's reasonable that work cover pay, and he'd have to argue his case based on medical evidence, I think, that where the GP would say that it's a reasonable medical expense.
And does it matter if it's a physical consequence or psychological? Probably not.
No, he's got an injury and you know, a significant back injury. He might have had a back operation, and that's affected him.
So it doesn't matter if it's a mechanical defect or psychological. He should really get it if it's reasonable.
If it's reasonable, and the doctor said it's reasonable for, dare I say, marital harmony, and also for his rehabilitation back into the workforce. We'll come back with more queries and questions, and we'll have a short break. See you after the break.